defense?
Ms. Salazar, what is your relationship to Cody?
I'm mother to him.
And when prior to being incarcerated, where was he residing?
He was living with me.
Okay, and his bond is currently set at $100,000. Is there what have you made any inquiries or tried to get a bond in that amount, or is that above?
Yeah, that's way too, I can't afford.
And are you currently working?
Yes, sir.
And what do you do?
All right.
Where I
so-
work here? Sorry.
Just off the record for a moment. I know the witness. I think everybody knows the witness. We know where she works,
All
so
right.
you don't need to get into any of that.
Okay. And we're here today asking for a reduction of your son's bond. Is there a certain amount that you think that you would be able to afford?
I mean, I don't really have a lot like to say, maybe 500 I don't.
A mother begs for a $500 bond, but the judge holds the line on a violent felony with a deadly weapon.
All right. Cody Salazar.
Present, ready, Judge.
You're welcome.
Morning.
Good morning. State, did you tender an offer?
Your Honor, at this time, we have been conferring. We had tendered an offer, defense has a counter offer. Before the state can actually consider that, we're just waiting on CPS records.
All right, so where are the CPS records? Because this case has been on the docket since November.
We subpoenaed them last week, Your Honor.
All right, so are they in the cut? Is there an open CPS case?
There is,
I don't know if there's a legal case, Your Honor. I think there's just on the regular CPS side.
I think it's in family-based.
All right,
rather
so
than legal.
has anybody reached out to the CPS caseworker?
I can ask our advocate to do so.
All right, I'm recalling this back for February 20th. That's Thursday.
We can do it next, well. Any chance for the 27th?
All right,
Just a week later.
all right, I'll put it on.
And Judge, while we're here, my client's been in custody since September. We respectfully request a oral motion for a bond reduction with.
Well, the way the law is now, you'll have to file a motion and I'll hear it and we'll put it on the docket as soon as you file it. If the state is waiving notice.
I think there's one on file, but we'll get it set for the
If it's
20th.
if it's on
I
file,
think my client, actually, Judge.
all right, if you want to adopt your client's motion, if the state is waiving notice, then I will hear it.
Your Honor, I would need to look at the motion and maybe just confirm, see if there's an agreement that can be reached.
Okay, Judge.
All right.
I'll just file one. Let's just do it for the 27th.
Well, they're saying that they'll look at the motion and see if you all can reach an agreement. So do you want to talk to them now? Or do you want to file your own and come back on the 27th?
We'll chat right now.
All
I'm
right,
here.
thank you.
Let's chat.
Sure.
Have a seat, sir.
Hey, Judge.
Yes. Yes.
We did look at the motions that were filed and we are not able to come to an agreement.
All right. So if you all want to have a hearing on it, I'll have a hearing on it.
Okay.
So is that what you all are requesting?
Yeah, just oral argument, Judge.
All right, so could you pull the file on Cody Salazar and see if you can find the defendant's motion for a bond?
Yes.
And then after this case, I'll take up Tony Niera. State, did you have a chance to review defense counsel's motion under 32.01? It is a drug case. I think it's off docket. Let me give you the cause number. It's NITMAG number 747949. And defense, if you have a copy of your motion, if you could tender it to the state. If you do not, I can give them this one.
It's the only copy I had.
Ah. Oh, no problem. Counsel, if you give them this one and then just return it to me because that's the only one I have.
Yes.
All right, thank you. And then after Niera, it's gonna be Castillo. Mr. Salazar, if you'll come down. All right, so Mr. Salazar, I'm in receipt of the motion that you filed. What I can tell you is unless there's an exception, PR bonds based upon the legislature and the rules they pass and the laws they pass, PR bonds are not given for violent offenses. And because this is an aggravated assault with a deadly weapon, you're not going to be able to receive a PR bond from the court unless there's some exception that your attorney wishes to present to the court. So with that being said, the court is calling, let me find you, 2024 CR 009128, State versus Cody Salazar. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Defense.
Robert Gear for defendant Cody Salazar, Judge. We're ready.
And are you Mr. Salazar?
Yes, ma'am.
All right. And defense, are you adopting your client's motion to set, well, it's a motion to grant a personal bond. Are you adopting that motion?
Yes, Judge, we'll adopt that motion, and we'd like to argue, if not for a PR bond, for a reduction in bond as well.
All right. So state, the motion that the defense counsel is adopting is a motion requesting a personal bond. That's it. It's not a motion for a bond reduction. So any objection to defense counsel amending his client's motion and requesting a bond reduction?
No, Your Honor, and I will state for the record that there were a couple motions filed. I do believe one of the ones the defendant filed was a motion for reduction of bond.
All right. Do you have that motion? If you all could print that out. All right. So defense, it's your motion. You may proceed.
Yes, Judge, may it please the court. My client was arrested on or about September of last year. We've been coming to court since November. State's attorney is correct that we have been conferring at every court setting. However, we're still here in the need of more discovery in the way of CPS records. And since my client obviously has been to court every day, but not only him, his family's been here. His mother and sisters have been very supportive of him. Bond and bail should be set in an amount that is sufficient to require or have the defendant submit to court and make all his court appearances. There is also a condition that I saw on the bond by the magistrate of a GPS with house arrest, and considering the nature of these charges and that bond condition, I believe it'd be in the best interest of society and my client and myself as representing him and being able to discuss this matter with him, that the court reduce his bond to a reasonable amount so that he can bond out, number one, because he has been sitting there without much movement on the case because we're waiting on discovery and waiting for CPS records. Number two, it'd be easier for myself and him to communicate were we out, should we have to prepare for trial or any hearings or other further settings in this matter. Considering the conditions on his bond, we believe that those are adequate enough to secure himself with society and in the eyes of this court. And therefore, Judge, we'd respectfully request that the court reduce this bond to a $20,000 to $40,000 bond range, so that my client, with all the conditions that are already in effect, will move my client's constitutional rights. Thank you, Judge.
All right. So what bond are you saying he can make? And do you have any testimony to determine the bond amount that he can make?
I'd call Cody Salazar, Judge.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
No.
All right. You can lower your hand, state your name for the record.
Cody Salazar.
All right. Defense, you may proceed.
Thank you, Judge. Cody, at the time of this arrest, where were you residing?
I was at my mother's
And you've resided there for quite some time? And you have been incarcerated how long?
for 5 months now.
Okay, so you currently don't have any occupation, and you're not working. And if you were to be released, you'd have to look for a job because you don't have one waiting for you, correct?
Yes, sir.
But your mother does work, correct?
Mhm.
And she's had a steady job for quite some time,
Yes.
and she cannot afford a huge bond as the current bond amount is at 100,000. That's a little bit out of the range.
Yes, sir.
Do you believe she'd be able to afford a $20,000 or $30,000 bond?
Right now, I have to ask her. I mean, I don't know. I don't really know.
would it be easier for her to afford in the bond in that amount than what the bond is currently set at?
Oh, yeah.
And property, other than her house, does she have any other property that she may be able to sell or get money for a bond?
I don't think so.
Okay, do you have any property that you'd be able to sell? or get money for? So you're asking this court to reduce your bond to an amount that you believe that your mother would be able to afford to get you. Sorry.
All right, so we can go off the record. So what I need is, what have they done to secure a bond? How much money do they have? Do they have any money in the bank? So,
Judge, if I may?
Yes.
May I call another witness?
well, just one second. Any questions, State?
No, not for this witness, Your Honor.
All right, thank you. Yes, you may call another witness. Yes, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Salazar.
All right, defense.
Ms. Salazar, what is your relationship to Cody?
I'm mother to him.
And when, prior to being incarcerated, where was he residing?
He was living with me.
Okay, and his bond is currently set at $100,000. Is that, what, have you made any inquiries or tried to get a bond in that amount, or is that above?
Yeah, that's way too, that's, I can't afford. That's-
And are you currently working?
Yes, sir.
And what do you do?
All right.
Where I
so-
work here? Sorry.
Yeah, just off the record for a moment. I know the witness. I think everybody knows the witness. We know where she works,
All
so
right.
you don't need to get into any of that.
Okay. And we're here today asking for a reduction of your son's bond. Is there a certain amount that you think that you would be able to afford?
I mean, I don't really have a lot like to say, maybe 500 I don't really have, but I mean, I maybe take them out with 500, but I know it's not crazy, I know. But I like,
And you did hear the judge's announcement and
right,
about a request for a PR bond is not
right, they couldn't do it.
acceptable in this
Right,
case.
yes,
And so you think that $500 may be the maximum amount? Do you have friends or family that you could borrow any money from that may be able to assist you in getting this bond?
it would just be hard for me to pay that back, and I don't want to be in debt, I pay my bills and I try to, it's just,
Do you have any property that you'd be able to sell that's unencumbered by any debt that may be able to?
No. I do not,
That's all I'm saying.
sorry.
All right. Thank you.
I'll pass it to Ms. Judge.
Any questions?
No questions.
All right, thank you so
I'm sorry,
much.
thank you.
Thank you.
Sir.
All right, any other witnesses?
No, nothing further, Judge. We'll rest.
All right. State, any witnesses or evidence?
As far as evidence, Your Honor, the state would enter in, I guess the police report, if you can give me just a moment to grab that.
Okay.
No, the state would also state exhibit 1.
Any objection?
Defense has reviewed it, Judge. We have no objections.
All right, let me just review this. All right, the court has read State's Exhibit number 1. The court will hear argument from both sides, defense.
Judge, based on the client situation, the fact that we've had several court hearings and we've conferred with the state, we believe we're moving this case along. My client's been incarcerated since September. Considering the fact that we're waiting on more discovery and that there are special bond conditions put in place, we respectfully request that the court reduce his bond in the amount that he may possibly or his family may be able to afford. Thank you, Judge.
State?
Yes, Your Honor, regarding the discovery, we did just confirm the existence of it last week as well. I'm sorry, on the
Just her.
6th.
That's correct.
On February 6th, we confirmed the existence of that discovery, and we did send a subpoena out last week as soon as we found out about it. So the state is doing everything in its power to get those records as quickly as possible. On the other end, Your Honor, this is a violent offense. The facts alleged, as the court has read, are violent, and this victim is scared for her safety. Additionally, the defendant is a convicted felon. He is a repeat offender. He's got a prior conviction for in 2017. For a second-degree felony offense, and because of those two things, Your Honor, the facts of the case and his prior criminal history, the state believes that he is a danger to this complainant and to the community, and would respectfully request that the court keep the bond in place at $100,000.
You have final argument.
Judge, there are special bond conditions to ensure the safety of society and for the victim. My client and this victim have not had any communication in over 3 years. I would be going to his home under house arrest where the victim is nowhere to be around. So to argue that he may be a danger to her is inadequate at this time. Therefore, we believe that the issue here is what amount of bail is sufficient to assure his attendance in court. And therefore, we respectfully request the court lower the bond to $20,000. Thank you.
All right. And state, has the defendant ever failed to report to court and previously in other cases?
Let me double check that.
All right, this is what,
I'm sorry, the only thing I have is that he was a post-indictment fugitive in the prior case, but
all right. And then we understand why post-indictment fugitives happen. It has
Yes.
nothing to do with his not appearing. All right. And then the court does notice that there are potential mental health issues. So you're still under oath. Have you ever been diagnosed with any type of mental health issue? Have you ever received or seen a psychiatrist?
I think at a young age that I was,
Okay. All right, this is what the court is going to do. Court is going to set the bond at $85,000. There's to be no contact with the complainant and no contact with minors. There's to be full GPS, waive fees. And there's to be a referral to Center for Healthcare Services. Is there anything else from either side?
Nothing further from defense, Judge.
And I'm
Thank you.
sorry, one other thing I'm going to add, and it's based upon what I read in State's Exhibit number 1. I'm going to add regular UAs. All right, thank you.
Thank you, Judge.
thank you,
welcome.
Judge.
You're welcome. Have a good one. 2024 CR 3950 State versus Trevor Morse. Could our parties approach and announce for the record for the state? For the defense?
Rene Munoz.
And are you Mr. Morse?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, Your Honor.
And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Probation, there are no applications. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
yes, Your Honor.
All right. Did you review the document entitled Court Admonishments and Defendants Waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
All right, you're charged with unlawful possession of a firearm by a felon as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
in my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, that is correct.
Mr. Morris, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 7 years in the prison. There's a $2,000 fine, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That is correct, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it, and did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal?
Yes,
The
ma'am.
only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence?
State offers states exhibit number 1 and attachment.
No objection.
All right, state, you may be excused. Did you review the waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, off the record for a moment. State,
We did oral motion to amend the indictment.
yes. So with regards to the indictment, are you all still proceeding on the indictment as presented, or state you're asking to amend?
Your Honor, the state moves to amend the indictment to change cause number to 2017 CR, and then the remainders that are in complaint.
Any objections?
There's no objection from the defense, Judge.
All right, Mr. Morris, do you understand that that's a substantial change to the indictment and a substantive change to the indictment?
I don't really understand what that means, ma'am.
What it means is that because there's been a substantive change to the indictment, your attorney is entitled to 10 days to prepare for trial.
You understand? Yes, ma'am, I understand.
All right, so do you wish to proceed, or do you wish for your attorney to have more time to prepare?
Wish to proceed, ma'am.
All right. Then state you are, the court will grant without objections the state's request to amend the indictment. And the indictment is amended with regards to the cause number that makes your client a felon. And so the cause number that is listed in the indictment is 2018 CR 8895B. And that will be changed to 2017 CR 8895B. All right, then state you wish to offer into evidence the waiver and consent to stipulations of testimony and stipulations.
No
All right.
objection, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Oh, and state you may be excused. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor,
Anything you wish to say on behalf of your client?
we ask the court to respectfully follow the plea bargain agreements. In relation to my client's matters, we do feel like he has some mental health and substance issues that contributed to him being placed into the judicial system. We're asking for the courts to hopefully recommend a therapeutic community inside the institutional division judge. And with that being said, my client has learned from the mistakes that have led him to this point, and definitely going to use it as a learning experience, and with the goal to never re-enter the courtroom again on any future charges.
All right, then the court will follow your agreement. The court will find you guilty, sentence you to 7 years in the prison. There's a $2,000 fine, time and money to run concurrent, credit for any time served. There's to be no contact with Monica Yvette Vargas or the Gus Garcia Apartments, San Antonio, Texas 78207. And the court will recommend the therapeutic community. Therapeutic community doesn't increase the time that you're in custody, but it's hopefully to help you rehabilitate. Do you understand?
Yes.
I do not have the jurisdiction to force them to place you in the program, but on the judgment, they'll see that I'm requesting it for you. You still will not be considered if you do not request it yourself. Do you understand?
Yes.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And you should know by now, you are not allowed to own or possess any weapons or ammunition. Do you understand? If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? All right, good luck to you.
Thank you,
You're
Your Honor. May I be excused?
Yes, thank you.
Every ruling has a reason. The family asked for $500. The judge gave them a number, but she also gave them conditions. That is how this works. If you want to see more real Texas courtroom moments like this one, hit subscribe. Court Beacon TV shows you both sides, the request and the response.